we're not allowing our first debater to respond to those remarks in the interest of trying to have time for the audience to participate. But we are asking Professor Ohlin to help us understand. Clearly, we see a disagreement here. But what is the core of the disagreement and how we characterize it? What we see so far? Please.
Thank you. I'd like to thank the speakers for their excellent presentations. I have two questions. The first is designed to excavate in more explicit terms what I take to be one of the core tensions between your positions. And the second asks you to extend the analysis to an area that I think neither of you covered. So, the first question pertains to the concept of armed conflict. Everyone understands that war is a military event that has a colloquial understanding. Everyone knows, in a kind of vague sense, when a war is going on, but as both of you know, armed conflict is also a legal event. It's meant to structure the consequences of a legal analysis. And clearly there's some disagreements between the two of you over the application of the concept of an armed conflict. But I was wondering if you could perhaps explain in more explicit terms what exactly is an armed conflict, right? What are the standards for determining whether or not there is an armed conflict? Who can be a party to an armed conflict? Can a non-state actor be a party to an armed conflict? All of this is leading to, right, this sort of central question of application. Is the United States in an armed conflict with Al-Qaeda? That seems to be what we're getting at and what we're disagreeing with here. Or is the United States involved in an armed conflict with the affiliates of Al-Qaeda, which are operating under the banner or the language or the name of Al-Qaeda? And if this is an armed conflict, what type of armed conflict is it? Is this a transnational armed conflict? Is this an international armed conflict? Is this some sort of hybrid armed conflict for which we do not even have a label? So how do we understand the current conflict within the traditional categories that have, up until now, structured the law of war? So that's the first question, which I hope will help excavate the disagreement between the two of you. And the second question, which I take it that neither of you addressed, but which I think is central to understanding a lot of the anxiety regarding targeted killings, specifically in the United States here. I'm not so much talking about the anxiety and complaints internationally, but the anxiety within this country regarding targeted killings. And that is the question, what difference does citizenship make to the analysis, if any? In that 2003 drone strike that was referenced in both of your presentations and in Professor Evangelista's introduction, there was in fact a US citizen who was one of the victims of the attack, although it's not clear whether or not he was actually a target of the attack, but there was an American citizen. And then famously, in the case of Anwar al-Awlaki, as both of you know, he was specifically targeted despite the fact he was an American citizen. And the question is whether or not the citizenship of the target, in particular the American citizenship of the target, changes the analysis. Does it produce a extra level of due process protection that non-citizens do not receive in targeting decisions? There were decisions by members of the administration recently which seemed to suggest that there was a kind of due process analysis that was triggered when Americans were potentially triggered by a drone strike. So those are the questions I would like to have both of our learned speakers address.
And remember, our response has to be brief.
No, those are great clarifying questions. So, what is
do I get to start? Thank you. Thank you. Yeah, I guess we'll just keep the orders. Professor Lewis gets the last word, so don't anyone think this is going to be unfair and starting again. I'd like to answer both of these questions together. Basically, what is an armed conflict and does U.S. citizenship matter? By reflecting on Professor Lewis's presentation, and I note that he did not attempt to defend this concept that has been promoted since 9/11, that the U.S. is in a worldwide armed conflict against Al-Qaeda. He has written, and I on some of his writings that suggest there was some kind of worldwide armed conflict all over the place on territories where the country has never attacked the United States. But he didn't defend that position today. Instead, he looked at the particular facts of Yemen, of Pakistan. He left out Somalia. And I think that is the appropriate way to look at this. Are there facts that can justify the military force represented by Hellfire missiles with regard to the U.S. attacks in Yemen or Pakistan? He gave you a set of facts and analyses that I don't think bear out under scrutiny. So this is here's the question, what is an armed conflict? Well, there was no armed conflict in Yemen in November 2002 when the U.S. unleashed its first drone attack, because the facts are international law determines what an armed conflict is and the right to use the heightened amount of military force in an armed conflict when there are real facts of fighting on the ground. I chaired a committee for 5 years of 18 of the best international lawyers in the world from 15 countries, 5 continents. We did 5 years of study, over 300 armed conflicts and violent incidents, and we were able to conclude that under international law, there is not an armed conflict unless there is intense fighting between organized armed groups. That was not the case in Yemen in 2002, and probably was not the case until 2011, when the Arab Spring came to Yemen, and students in particular finally protested and pushed out their dictator who had been doing the U.S.'s bidding, and there was a period of chaos followed by elections, and then a new person has come in, and we're very unclear about the facts in Yemen today. We heard testimony from Yemanis last weekend in Washington, D.C., that in fact the Yemanis may be making things easy for the U.S. to continue to carry out military strikes by setting up situations to look like armed conflict that are not really armed conflict. But this is, for the most part, the fighting that has occurred in Yemen has not involved the U.S. We're not interested in who actually has power in Yemen. We've been just going after particular people and doing this targeted killing of individuals, which is inappropriate in an armed conflict. We have not been invited to be part of any civil war in Yemen. And the basis for Pakistan, as Professor Lewis says, there has not been this organized armed violence between armed groups in Pakistan, no armed conflict. And you don't get to use military force on the territory of a country because they have failed to carry out their due diligence in keeping criminality at bay. We can do cooperative policing with Pakistan, yes. But notice for the major thing that they failed in, which was bringing Osama bin Laden to justice, we didn't use a drone. We used something much closer to law enforcement methods. And that's how we should have been carrying out every action in Pakistan with regard to people we suspected to be terrorists. Better that we do it in cooperation with Pakistani authorities and stop going over the heads of the elected people in Pakistan to shady figures in the ISI or the military who are giving us all this consent to use military force in a country not engaged in armed conflict. And does the U.S. citizenship matter? Of course not. I mean, one of the real indicators that this is a fictional war that the United States says that it's engaged in is when Eric Holder, the Attorney General, gave a letter to Senator Rand Paul on the floor of the Senate and said if there is a worldwide war in which we're allowed to use drones, we will not use those drones. We have no legal right to use drones against Americans in the United States. Well, either it's a worldwide war in which these persons who are associated with Al-Qaeda or other terrorist groups pose an actual armed challenge to the United States for which we are lawfully allowed to use military force, then we should be able to do it in this country too. We're part of the world, or not. And the very fact that the Attorney General Holder said we have no legal right is just more indication that this is a fictional war. The only place where there is a real war going on today that the United States is involved in is in Afghanistan, and that is with the permission of the elected president. That is with the invitation of the elected president.
I don't think that Holder said that there was no legal right. I think
Yes,
that
he did.
he said there's no legal right.
There's no legal
Legal
right.
right.
He says there is no legal right.
In the United States.
Just check the language before our debate today. No legal right.
I am not aware of anyone that regarded the bin Laden operation as a law enforcement operation. And anyone that talks about the instructions that the individuals were given there knows that the only way that bin Laden comes out of that alive is if he surrendered. Right? Surrender is a law of armed conflict concept. You cannot kill someone that is surrendering or is war to combat. If it's law enforcement, you can't kill someone until you have given them the opportunity to surrender. Or if they are posing an imminent threat. And yet in all of the discussion of what went on there, there is no evidence that bin Laden was armed, that he took shots at anyone, or that there was an opportunity offered to surrender. That was not a law enforcement operation. It was a military operation in time of war. And if that is a military operation in time of war, the legal justification for that is identical to the legal justification for any other use of military force in the same area, in the same circumstances. We are targeting members of Al-Qaeda and the Taliban in Pakistan. And now to turn to the question of who can be a party to an armed conflict, you can have armed groups in an armed conflict that are not state actors. The problem with the way that the laws of war were written, and this is just a conceptual problem at the time, was that there were two types of wars. There were international armed conflicts, France versus Germany, as I said before, the traditional wars, which we don't have anymore. And then there were non-international armed conflicts, NIACs. And that's the term that we use, and we have an additional protocol 2 that describes them. We have Common Article 3 that talks about them in the Geneva Conventions. So these were understood to be a kind of war that was out there. They were also understood to be civil wars. That's what everybody understood a NIAC to be until 2001. And then suddenly there was this situation in which you have a non-international armed conflict, because it's not between two nations, but it's not internal to one nation. This is not a civil war. This is not AQAP versus the Yemeni government. This is not the FARC against Colombia. But any armed group can be a participant in a non-international armed conflict. It's just that until 2001, those were always internal to one country. Now I think you use the term, Professor Ohlin, of a transnational armed conflict. Transnational armed conflict, I don't believe, is officially a legally recognized term, but it's something that gets at the idea of some kind of hybrid between traditional non-international armed conflicts, that would be civil wars, and international armed conflicts between two states. We're now talking about a conflict between a state actor and a non-state actor that crosses international boundaries. That's a transnational armed conflict. What are the laws applicable to that? Do we have some kind of hybrid? And I think that most scholars in the field believe that some form of hybridization is appropriate. And in fact, you see that on both sides of the debate. You see people that are more aggressive and more interested in a wider scope for the laws of war, using targeting rules from AP1, which is designed to be an international armed conflict treaty. And you see, but at the same time, when you have a non-international armed conflict, you see human rights members, people who are interested particularly in the rights of Guantanamo detainees and their due process considerations, trying to use the same thing, saying Protocol 1, international armed conflict rules, ought to apply to how we treat Guantanamo detainees. And that idea has also been accepted by the U.S. Supreme Court and others. So you have a bleed over between the laws that govern international armed conflicts and laws that govern non-international armed conflicts being applied to this conflict between Al-Qaeda and the United States. And I agree that U.S. citizenship does not matter ultimately in who you target. I could go back to Kieran and others like that, but we don't have time for that now.
Thanks. So just a couple of words from Professor Ohlin, where we stand, and then we open it up for the audience.
So I want to keep my own views carefully guarded here, and instead provide some background explanation to, I think, provide some structure to this disagreement that I've witnessed between the two of you. And I think it might be helpful primarily for the non-lawyers in the audience. When lawyers and philosophers talk about the legality of warfare, they usually are discussing two related questions, which both lawyers and philosophers like to keep separate, but which the public will often discuss in tandem. Now, what are these two aspects of justice? In order to sort of keep out non-specialists, both lawyers and philosophers love to use jargon, right? They're obsessed with jargon, and this situation is no different. And the two spheres of justice, when we talk about war, go by Latin terms: jus ad bellum and jus in bello. Well, very fancy Latin words, but they have a very simple meaning. Jus ad bellum refers to justice in the decision to go to war. Did you have a just cause for launching your military force? That's one type of justice to discuss. The other type of justice to discuss is jus in bello, which means justice in the conduct of war. Was your conduct in the manner in which you pursued the armed conflict just? Were you using the right types of weapons? Were you using the right type of methods? Were you attacking the right type of people? Were you conducting war crimes? Now, the interesting thing about the two spheres of justice is that lawyers keep these two completely separate because there are different laws and principles that govern each. And they are so separate that the analysis on the jus ad bellum side regarding justice in the decision to go to war is completely separate from the rules regarding how you conduct the war. So that in World War II, the general view was both Germany and the United States, right, were subject to the same rules of warfare, jus in bello, regardless of who was the aggressor and who was the victim on the jus ad bellum side. So the two analyses are kept separate. And what struck me during the debate here was that there were wide-ranging debates that were flowing in and out of this divide between jus ad bellum and jus ad bello. Not collapsing them, but there's so much disagreement that I think it structures or spreads across both parts of the divide. So as to jus ad bellum, the analysis from Professor O'Connell, I think, concentrates very tightly on the provisions of the UN Charter, which explain that there is a prohibition against using military force in Article 2, and then the UN Charter says that there are exceptions for a Security Council authorization or for self-defense. And the operations conducted by the United States, in the view of Professor O'Connell, failed to live up to the self-defense standards expressed in the UN Charter. And that's the kind of focus of her jus ad bellum complaints regarding the U.S. targeted killings program. Whereas when you hear from Professor Lewis, he's inclined to concentrate on the partnerships between the United States and the various countries in which the targeted killings are conducted. And so, for example, I think from Professor Lewis's perspective, there is no problem regarding self-defense or jus ad bellum in Yemen because the United States is operating with the consent of the Yemeni government. So there's no violation of sovereignty when the U.S. operates in Yemen because they are operating at the invitation of the Yemeni government. So there's no violation in justice in the decision to go to war when there's the consent of the government. And then on the other side of the spectrum, right, there's a question of, well, how far do the rules of armed conflict, right, the ability to attack a combatant wherever they're located, right, how widely or how narrow